sit down because I'm not quite healed up, and I will need to finish class a few minutes early today. I'm sure I would be very disappointed because I have a flight to catch. PC tomorrow. There are the Obamacare arguments, and I'm getting sworn to the Supreme Court bar tomorrow morning. So I will have to leave. Thank you, thank you, thank you. You too can do it for the small price of $200 and being the member of the bar for 3 years. If any member of the bar moves to admission, I know every other year, South Texas has at least one member, and they do like a group trip for the Alumni Society. So after you've been a member of the Texas bar for 3 years, you can then petition to be admitted to the U.S. Supreme Court bar. I think they did this 2 years ago, but they usually bring a group of people. They all stand up, and one person says, Mr. Chief Justice, may it please the court, I move for the admission of, John, Sue, Mary, whatever of Texas. I am convinced they possess the requisite moral whatever. And the Chief Justice says, you are now admitted, and that's it. It'll take all 3 seconds, but I will be there tomorrow morning. And tomorrow morning is also the big Obamacare case, which I'll be in arguments for. I'll be back here tomorrow night. I'm there barely 24 hours, and I will bring you an update later.
What's the advantage to being admitted to the United States?
Absolutely nothing. No, that's not true. That's not true. So if you ever want to attend oral arguments, there's 2 lines. There's a bar line and there's a general public line. The bar line is much easier to get into. So that's actually one of the only major benefits. Yeah. Is your hand up or you just?
Well, I was going to say something I was going to say you should organize
You think I can get you guys tickets? I'm not that important. No, I'm serious. I mean, the Little Sisters case, I mean, one of the perks of getting sworn in is I have a guaranteed seat tomorrow. But were I to actually want to get tickets from the general public, I'd have to get there in a couple hours. It's probably been a 24-hour wait for this case. Even for the lawyers' line, it'll be at least 20 hours. So probably lawyers will be getting there around 3 a.m. this morning. So it's a really long wait. I think I've told you, I've waited overnight. Thankfully, as a member of the bar, I will not have to do that anymore. I'll just have to be cold and wait for a little bit earlier. Okay. Yeah.
Do you have any input on the nominee?
I'll get to that in 2 minutes. Okay. So second, I finished reading your papers. I can't give them back to you yet because some of you don't follow instructions. So several of you didn't put the correct exam number on the paper. Several of you put what I think was your exam number from last semester. That doesn't help me. So I've had to actually give the books to the registrar, and they're trying to figure out who's who. But the number one most important thing about taking an exam is writing your name on it or writing your number. So for the future, make sure you write the correct number because there are about 4 of you. I have no idea who you are, so I can't give you a grade. But hopefully that should be resolved by some point this week. It's out of my hands now, and I'll probably get back to you later this week. What I'd like to do is have a review session to go over the midterm. And the only day when you don't have class is on Friday. Now, I know it's Good Friday, which I apologize for, so I'll be recording it. Do you have any Langdell or other things on Friday that I should be aware of? Because my morning class did. What time? Oh, one at a time.
It's 1:45 to 4 o'clock.
Okay. Do you have anything at 12 noon? You have Langdell at 12 noon. So you have Langdell at 12. You have a mandatory thing at what time?
They start registration at 1:45.
And then what time's that over?
4.
Okay. What times do you not have class on Monday? After 3:30.
Because we can have a long class.
Look, Monday at 4 o'clock. Does anyone have class? Monday at 4 it is. Okay. I'm glad we worked that out with minimal. It'll be like from 4 to 5:30 on Monday. We'll do a ConLaw review session. Monday at 4 p.m. I will do a review session. If you cannot make it, or you're detained, or wherever the heck you are, it will be recorded. I do these for your benefit, not mine. So hopefully everyone will come. See, actually, my property students, they got the Friday at 4 p.m. slot because they have the same deal you do. I'm going to take my coat off because I'm getting over a cold. I'm not quite there yet. Okay. Anyway, so yeah, so I'll get you then. I'll get your papers back then as soon as I can, but it'll probably be later this week. I may just even hold them on to you for Monday and give them back to you the day of the review, depending when the registrar gets around to telling me who is who. Okay. So any questions on that? Okay. The next thing I want to talk about, all right, so you asked about the nomination. So we're in a very interesting spot. And long before Justice Scalia passed away, I had given a series of speeches on the Supreme Court nomination. And the point I basically was conveying, and I said this months ago, it's on YouTube, you can find it, it's not a secret, is that in our current climate, I don't think it's any longer possible to confirm a justice unless the president and the Senate are of the same party. I made this point at times. The consequence of that is that we may have extended vacancies. And I've been saying this for months, and unfortunately I've been proven right. Until the next election, I mean, I don't think we will see a confirmation hearing of Merrick Garland between now and November for sure. There's a chance that if a Democrat wins the election, the Republicans may confirm Garland. There's another chance that Garland may withdraw and they can't confirm him, and then the Democrat president can make the nomination. Or if a Republican president wins, he will make a nomination. The chance of Garland being confirmed this year, I think, are pretty close to zero. But bigger picture, and I always like to give you guys the bigger picture. The process of judicial confirmations has been increasing in pressure over the last at least 30 years. And there's no one single event or one party to blame, but each step has been ratcheting up the pressure more and more and more. And I think we've actually come to the point where we're not going to see justice confirmed unless the president and the Senate are the same party. Don't kid yourselves for a second and think that if, Justice had died in 2008 on President Bush's final year in office, that the exact opposite wouldn't be happening. You'd see the exact same return. Don't kid yourself for a second. So if that's the case, we will, I think, see extended vacancies in the court far beyond this. The reason why we're at this point is what I hope you've all begun to realize, that the Supreme Court is extremely important, and indeed, perhaps from my biased point of view, is one of the most important things a president can do. So any potential, hope for compromise doesn't matter anymore because it's so important. And even if the seat's empty for a year or two, that's not that much of a price to pay for picking the wrong person for 30 years. I mean, very few of you remember the name of Doug Ginsburg. Maybe a couple of you know the name of Robert Bork. But these are men nominated to fill the seat that's now filled by Justice Kennedy. You all know Justice Kennedy because he writes your ConLaw book. But had either Bork or Ginsburg gotten through, your ConLaw book would look very, very, very different. It'd be a little bit thinner too, less reading perhaps. So that's my general take on the Garland issue. I don't think he's getting a hearing. It's not going to happen.
Speculation was that he may be able to get pushed through, you know, in the lame duck session.
Possibly.
What are your thoughts on that?
I mean, the politics of this are interesting because Garland, you know, he probably wasn't Secretary Clinton's first choice. She may feel pressure to renominate him, or she may not. And depending whether, and I don't see the Republicans wasting their time confirming him. Someone else do it, not them. However, if it becomes clear that Clinton will nominate someone else, that's a different situation.
Can the Senate be compelled in any way to hold hearings?
No. The Senate's prerogative of holding hearings, absolute. They have no obligation to do anything. None. Indeed, what comes around goes around. In 2006, then Senator Obama tried to block Samuel Alito from having a hearing. Tried to block it. Comes around, goes around.
Do you feel that there will be, or there can be some political backlash against conservative elected officials that we would maintain a hearing, or do you think that
People are rationally ignorant about the courts. It's funny, a recent survey said the majority of Americans want the Senate to hold hearings, and also 59% had no idea who Merrick Garland was. The courts, to my chagrin, are not a particularly high issue for the voting public. It's a very low issue. Immigration, jobs, terrorism, whatever else, right? It's a very low priority issue. I don't think any meaningful number of people outside perhaps of this building will care enough to affect their vote based on whether a Senate hearing is held. It simply won't. Most Americans can't name a Supreme Court justice. They vote. This is not an issue that matters. So really, I don't see much of a downside. There's not much of a political risk at all.
So if they don't hold a hearing, you don't think that one general election is coming up, that the Democratic candidate is just going to annihilate the Republican side over it?
I don't think voters care about this issue. It's hot now, but it'll fade real quick. There are bigger things. I mean, and I say this as someone who bemoans the lack of public awareness about the courts, but this is not a particularly pressing issue facing Americans, whether it's Merrick Garland or Antonin Scalia. People don't know who these people are. They have no idea who they are. They're going to change their vote because of some guy they have no idea who he is. You know, more people know who Kardashian is. They know who John Roberts is. I'm not being facetious, right? We have priority problems in our country, but it's a fact of life. They're rationally ignorant about these. Yeah.
What are the factors that the Congress considers whenever they decide whether a judge is good or not?
Well, that's a good question. So depends who you ask. Historically, the criteria was one of qualifications. Are they a smart lawyer? Do they have the background? Do they have the good temperament? Starting with the nomination of Robert Bork by President Reagan, who was a very prominent conservative, the strategy shifted from one of whether he's qualified, the fact that he's smart, to one of ideology. That is, does he agree with me on certain legal issues? Will he overturn precedents that I like? So today, I think both parties would agree that it's not enough to simply have the intellectual firepower. But there's also the criteria that your politics and policies and views match up with those voting for you. That's actually a very good segue. So last week, when all of you were busy chilling in the beach somewhere. Your humble law professor was testifying before Congress on the issue of executive overreach with respect to immigration and healthcare. Yes, the very same stuff I bore you with, I was boring the United States Congress with. But there was one point that I wanted to play, and the audio is very low. So I remember Natalie before the break asked me a question of like, do I think the justices are partisan? Or remember you asked me that question? What did I say? So you remember your question?
You said that you didn't think so. And perhaps you were being naive.
Okay. Good memory. Very good memory. So she actually remembers what happened before the break. So I was being questioned by Representative Darrell Issa from California. And I swear this question was not a plant. I'll repeat it in a second, but listen to what he says.
But I think there's two interesting points. Justice Roberts, siding in the majority. Oh, by the way, when you teach law, do you teach that justices are partisans, that one's a Republican, one's a Democrat?
I do not, sir.
So, Mr.
So he asked me, I swear to God, when you teach law, do you teach your students that justices are partisan? I said, I do not, sir. Is he a member of Congress? I think you must have pitched him a question. Yeah, so I had a testimony, and I swear I almost started laughing when he was like, I'm going to play that in class next week. Ron, you can play the entire thing, but I said my students are on spring break now, but they'll hear about this. They'll hear about this next week. Where is it? Yeah, it is. So you can watch it later. It's 5 minutes. It's short. But the funny part was I actually called Congress lazy. I said they need to do more stuff to be assertive. So, you know, I'm sure I'll be invited back. Yeah, it's an interesting opportunity. But you get these questions. The questions you guys ask are so much better than the questions they ask. The questions they ask are so vapid and superficial. There's nothing deep there. I mean, students ask much better questions. But it was an enjoyable experience. I liked it very much. All right, yeah, last question. What? Well, he went on and started talking about something else. The thing you have to remember about these questions is that they're mostly making statements. They're not actually asking questions, so I'm more of a conduit to help channel them in the right direction. Some of them do ask questions. Actually, last year I testified, and one of the representatives went to U of H, but he says, I wish I would have gone to South Texas. Like, good.
He was going for when he asked you that.
So one of the other guys testifying next to me said the justices were partisan. And he called someone a Republican justice. And Darrell Issa did not like that. So you're welcome. So I said it under oath, under penalty of perjury. All right, any other questions? Nice way to slide back into the semester. Okay, so our discussion today continues on the 14th Amendment. We've discussed what maybe you might call the tough stuff, right? We've done Dred Scott, we've done Plessy, we've done the civil rights cases, right? We've done all these cases where you would think the 14th Amendment perhaps did more to eradicate various forms of governmental discrimination. But then we get to today's cases, the case of Cumming, Giles, and Berea College. And what these cases have in common is that in each case you have an act of segregation in one form or another. And in each case, the government won. But what's critical about each case is that not a single case was about reaffirming Plessy. Not a single case was about reaffirming the separate but equal doctrine. Each of these three cases vigorously avoided even talking about the 14th Amendment. You could sense it's almost like discomforting. Well, we're not talking about this. We're just going to resolve it here on these grounds, right? And what I want you to think about is why they resolve these cases this way. So when we did Plessy weeks ago before the break, whatever the heck that was, I raised an idea for you to think about. And I said, what would have happened in 1896, whatever year it was, in Louisiana, if the Supreme Court had come in and said, hey, New Orleans, you need to open up your rail cars to mix the races? And I asked a series of questions. I said, first, would New Orleans have listened? Probably not. Had a black person try to enter the white car, they probably would have been beaten up and lynched. Okay, so on the one hand, perhaps the court didn't want to be in the business of issuing a ruling that was going to be ignored. But I gave you a second frame to look at this issue. And the second frame was, what was the consequence of the Supreme Court blessing this segregation with a doctrine, the separate but equal doctrine? This signaled a green light to everyone saying, okay, guys, we can do this. Oh, we can do worse stuff too with this doctrine. It's not just train cars. It applies to schools and restaurants and everything else. So the court's decisions in this era were striking this weird compromise where on the one hand, they were upholding these programs, but then they did not want to reaffirm separate but equal doctrine. And that is what I think resolves the Cumming case, the Giles case, and the Berea College case. They were trying to resolve these very difficult legal issues without touching the Constitution, trying as hard as they can to make this about narrow statutory grounds. Any questions on that general frame? All right. Does anyone have any clue where we finished last time? You remember? Thank you, Ashley. Appreciate the honesty. I had no idea. Ashley, you want to tell me what happened in Cumming? What were the facts there? Can you speak up a little bit? Maybe my ear, I think I'm a little congested. I'm having some trouble hearing. I'm sorry. Mm-hmm.
So the colored people and the parents of the children were saying that they were entitled to the same benefit because they were all equal.
Good. Okay, so stop right there. So we have a situation here, right? Now, today we all think of public education, K through 12, as automatic. But that simply was not the fact in the 1800s. Most states didn't have public education K through 12. They maybe had it through primary school in the 5th grade. If a city decided to offer high school, it was not because they had a legal obligation to. It was because that's how they wanted to use their tax revenue. So, Luis, did the plaintiffs in this case challenge the fact that the schools were segregated in the first place?
No, they didn't actually court reviewed and they said they didn't know what the issue was, so they went ahead with tax.
Okay. Right. So here, okay, here, the plaintiffs were being very, how should I say it, tentative. Okay. They weren't coming out straight and saying, we think that these school systems are segregated and that's unconstitutional. Okay. Luis, why didn't they come out and say that? Do they want to be trying to overturn Plessy? Why do they not want to try to overturn Plessy? Yeah. Because Plessy established his doctrine not even a couple of years earlier, right? They knew if they went to a court and they said, we want to overturn Plessy, they would have been laughed out of court. So, I mean, look, these were not idiots, right? They're lawyers. They're smart people. So, okay, if we can't get integrated schools, at least let them be equal, right? Think about what they're doing, saying, if there's a white school for the girls, we want a black school for the boys, right? If it's really that separate but equal, let's at least try and get the equal part down. And for the first half of the 20th century, if you can imagine, the lawyers are trying to fight within Plessy, saying, okay, at least make this stuff equal. So, Luis, did it matter to the court that there was a school for white high school girls, but not a school for black students? Yeah. Why didn't that matter?
Because it's not up for the court to decide how the board should spend its money.
Okay, and here's the key. Luis, why is it not the court's business over how the city chooses to spend its money for taxes?
Because the board was elected by people to do that. So I mean, it's the board's job, not the court's.
Is that the case even if they're spending the money in a discriminatory fashion? According to the court.
No, if they were spending the money that way, then the court would be able to set.
Would they? But isn't that what we have here, though? Aren't they saying flat out we're spending money in a white school but not a black school?
So according to the Constitution of Georgia, it says that they should spend the money, you know, in a system that is practicable or something. So according to the law of Georgia, they're spending the money the best way they can.
Okay, and that's I think the right way. And again, the majority opinion is by Justice Harlan, right? Justice Harlan, the same guy who wrote the Plessy dissent and who dissents in the other case we have later today. Excuse me. What Harlan basically says, and this is almost like a cop-out, but it's like, look, if the school decides they can either have 300 students in primary school or 50 students in high school for the same cost, who am I as a judge to tell them to pick one over the other? Okay. This concerns the court's equitable powers. Are the courts going to sit there and supervise every single school board in the country and how they spend money on every single school program? Is the court going to supervise every single budgetary meeting and decide how they're going to appropriate their tax dollars? Harlan says that's not for me to decide. He almost, I don't want to say puts a blindfold on, but he almost like, you know, like a horse's blinders only sees what's in front of him. He puts blinders on to basically ignore the fact that this is a regime that's and making it impossible for blacks to get an education beyond primary school, right? That's not what he's looking at. But he says from this narrow perspective, I can't give them the relief that they want, right? Because think about it this way. So Rebecca, what happens if Justice Harlan agreed with the black students? What would the only thing the court could do in this case? What's the only thing they could actually do? And what would the injunction accomplish? It would shut down the white high school. Would it make them open up a black high school? Exactly. And this is the key point that Harlan stresses. Even if the court gave the relief, the only consequence would be there would be no white high school. And by the way, they can't make them spend money in a high school, so no one would get an education. So it's almost like the worst possible outcome would be to rule in favor. Now, you may be asking, wait a minute, why can't the court just order the school to build a second building for black students, right? Why can't the court just order them to spend more money on a black school, right? Was anyone wondering that when they were reading this case? Tariq, why do you think the court didn't even entertain the possibility of mandating that the city build a second school for black students? Right. At the time, whatever year this case was, 1899, yeah. In 1899, give me a second. In 1899, it would have been unthinkable for a Supreme Court to oversee how a city spends its money. Today, it's commonplace, right? You have school districts in the United States that are still under supervision by federal courts, still after 60 years. 60 years after Brown, there are school districts in this country that are still under federal supervision. That's the point of Brown, too. But at the time, it was unthinkable for a court to supervise how a city spends its money. Oh, I'm sorry. Your hand was up first. I'm sorry. I jumped over you. I'll get to you in a second, Dan.
So, and maybe Wikipedia or something could have told me more about this, but I was curious.
Don't use Wikipedia.
Well,
I once had a student, I swear to God, cite something from Wikipedia, which I said was wrong. He's like, no, but it's right here. And I was like, I couldn't believe it. It was embarrassing. Yeah.
Just about the background of it. Because the talk was all about, well, they took away the black kids' high school and made a white girls' high school. Does that mean that prior to that there had been like a co-ed white high school?
There may not have been any high school.
Because that's what it is, because if it was just like, well, they had a co-ed school and then they decided, you know, well, this co-ed thing's not working out, and then kick the girls out of the co-ed school, and it's like, well, just put them back in the co-ed school, and then everybody still gets an education.
Yeah, but you're trying to second guess their wisdom. And the point of Harlan's opinion is we're not going to start second guessing the decisions that the school board makes, right? They can choose to have a co-ed school, an all-girls school, an all-boys school, a school for, tall people, short people, whatever. That's not our business to second guess. Dan?
The practice of appointing a trustee to oversee implementation, is that not in place?
That wasn't even thinkable. Can you imagine any respectable member of the community in Georgia supervising desegregation of schools? The person would be killed. Right? I mean, I'm not being facetious.
Yeah.
Imagine, usually a lawyer in Georgia. I mean, if you ever saw the movie To Kill a Mockingbird, right? Think of Atticus Finch standing in the jail cell with a rifle guarding Tom Robinson. Yeah, think of that. And that'll be the guy, the trustee, right? You can trust him. Trust him to get killed. I'm not trying to be light with this. These are legitimate death threats if someone actually tried doing that. All right. Any other questions then on the Cumming case? But I want you just to sense in Harlan's writing how uncomfortable he is with this. Like he's saying, well, we're only deciding this very narrow issue. I'm not going to cite Plessy. I mean, this case could have been really easy, right? Cite Plessy, separate but equal, done. Done. Although in fairness, there was no equal school for high schools for blacks, so didn't even quite even meet the Plessy standard. But he didn't even cite it. Any questions on Cumming? All right, Jacob, you want to tell me about Giles?
It was a class action suit brought by a group that was denied. They applied to register to vote, but were denied the actual, I guess, the official registration to vote. I mean, they attempted to, and they filed in a timely manner before they were supposed to, and they were still denied the right to vote.
Okay. So what we're seeing in the Giles case, we don't talk much about the right to vote, but under the 15th Amendment, the Constitution prohibited discrimination to vote on the basis of your race. Okay. Shortly after the 15th Amendment, many states started to impose various restrictions that could be used to deprive the vote. So among them were grandfather clauses, such as in this case, where if you were registered to vote before a certain date, or if your grandfather could vote or something like that, you could vote. There were also these literacy tests, which are alluded to in this case. So for example, you'd have to like recite an entire passage of the Constitution from memory. If I gave you that on your exam, I think everyone's room would fail. To recite an entire article of the Constitution from memory, people memorize stuff back then much more. But I don't think, maybe I could if I tried. But it'd be really tough. I mean, I've tried taking these tests; they're awfully hard. So what happened in the city in this case in Alabama was actually the worst of the worlds, right? So if you could register to vote before a certain date, you can then vote for the rest of your life. But if you were not registered by that date, well, then you were subject to this other regime where you had to practice this literacy test. You had to be employed, and you had to own a certain quantity of land. Now, don't think for a second that this law is being applied equally. If you were a poor white person without property, they'd let you register. Even if you were a freed black with property and you can miraculously recite the Constitution, they'll still find a way to deny you. So this was a pretty, transparent method of disenfranchising blacks. There's not much secret about it. So this goes to the Supreme Court. Now, Catherine, what relief, what remedy was the plaintiffs in this case seeking? Yes. Yeah. They wanted to be registered on this, insane voting system, right? Catherine, what's the problem with asking the court to register them under this, insanely rigged voting regime? Yeah, you. Yeah. You're still up.
I guess it would basically validate.
Yes. Yeah. Think about that for a second, right? We have this voting system, which by all accounts is rigged. It's awful. The plaintiffs in this case are basically asking to be registered under this rigged system. For the court to order their names be added to the register, the court would be validating and indeed perpetuating this system. It's kind of messed up, right? It's kind of messed up if you think about it. On the one hand, these people need to vote. And the only way that they can vote is if they're registered under the law. On the other hand, to register them under this law is an acknowledgement that this law is indeed valid, right? So, Catherine, what would happen then if in a couple years some new guy turns 21, the voting age is still 21, some new guy turns 21 and he wants to vote? What would the court have to do then? And how would the court do that? No. Some guy who just turned 21, right? He wasn't around when this wasn't 21 yet when the 1903 happened. He comes to court and he sues. He says, "I want you to add my name to the registry. Look, you added my uncle over here. I want you to add me." Right. So you basically having a system where you would perpetually keep adding new names to this rigged system. Everyone see the difficulty, right? Now, Austin, what should the court have done? What would the correct remedy be in this case?
Well, they could have addressed the they could have addressed this
Putting aside what the plaintiffs requested, in an ideal world, what would the Supreme Court have done to this voting system? Struck it down, right? I mean, you guys are spoiled. You read all these cases from the 20th century where courts strike this down, they strike that down, they strike this down, right? You don't even think about it. Yeah, strike down the law, whatever. Had the court just struck it down and said, okay, go make a voting system that's legal, right? Go make a voting system that anyone can apply for who is of age. Awesome. Why didn't they just strike down the entire voting system?
They said it was a political issue that was better suited for the legislative and political department.
Yeah. So isn't that something, right? The court basically said that this discriminatory voting system, we're not going to strike it down because it's a political question, right? This is for the political branches to work out. Even though you have the 14th Amendment, even though you have the 15th Amendment, the courts did not willing to invalidate this act. But they go further than that. Zach, what would be the consequence if the court invalidates this voting regime? What would have to happen next? Well, they'd have to make a new one, right? And then what would the court's job be to make sure that the new one is working?
I guess somehow enforce it as legislation against it. That goes back to it would probably be a joke.
Yeah, I think it would be a joke. Think about it. Let's say the court invalidates this regime And then the city says, okay, we're going to make a new voting system, right? The Supreme Court would have to supervise. Trustee, to use Dan's word, right? The Supreme Court would have to monitor the new law. And not just monitor the new law, see how it's actually implemented in practice. Because imagine on paper you have this great law, but in practice at every single polling precinct, if a black guy walks up, they, oh yeah, go away, I'm not gonna let you vote today. That you won't see that by just looking at the statute on paper. So you would actually need not only a review of the statute, but you would need poll monitors, right? Someone at the actual polling station watching to make sure that's being complied with. Justice Holmes, who wrote the majority opinion, was a very practical man. I'm not a fan of his, but his point he makes here is probably right. The courts do not have the supervisory power to watch over every single polling precinct, not just in this state of Alabama, but in the entire United States. Because once they struck down Alabama's voting regime, every other city in the South that had a similar regime, their laws would also be struck down. And oh, by the way, the courts would then be responsible for supervising every single voting on every election day in the country. This is why in Brown number 2, which we'll get to in a couple minutes, the court says, we're going to let the lower court supervise the integration of schools. That was a very big deal. Because while the court in Giles was saying, listen, we can't supervise this, in Brown, they're saying, you know what? The only way to make this work is for the court to supervise every aspect of the schools. And that was a massive undertaking by the federal courts. And it radically altered the sorts of political powers that they had.
So why could they not have just invalidated the law or the voting system, and then later on when a black man's voting rights infringed, have them sue, and they go through the same system? Because wouldn't the lower court have to follow the precedent set by the Supreme Court in saying, well, you were disenfranchising these blacks, so this new law is doing the exact same thing, so it's also that. Why couldn't they have just gone to the standard?
So let me ask you this question. The judges in the Supreme Court, this case was what, 8-1, 7-2, right? They weren't willing to stand up. Do you think a bunch of local district judges in Alabama would?
No, but then wouldn't it have just still ended up back in the Supreme Court, and then they would have made the same decision again?
They didn't want to issue decisions that could not be enforced. Think about it, right? The court did not want to issue a ruling that would be disregarded. Because we get to the point of where people start ignoring courts, they start losing their legitimacy.
If I understand everything right, because one of the principal arguments they make is that they couldn't put them into the system because that would validate the system.
Right.
But at the same time, they registered prior to the law coming into effect and were denied. Theoretically, couldn't they have just grandfathered them in? I mean, this obviously would be limited to this group.
Yeah, but even the grandfather thing was illegitimate. What Holmes is saying without saying is that every aspect of this regime is illegitimate. This entire idea that even if you register by a certain date, that's also bogus, right? You can't do that. So it would still be validating the illegitimate system in any event.
Okay, so it's not just a test.
No, even the grandfather clause. Yeah. Yeah, Dan.
Oh, okay, so I guess what Holmes is saying, that this thing's too big to fail kind of thing, in essence.
Well, I don't know if I put it that way.
Well,
but
too large to change, really.
yeah, okay, no, I see your point. Yeah, I mean, he's basically saying we can't supervise this, right? We can't oversee this, so we're not going to.
But I guess my question is, why doesn't he provide some sort of a scheme or guidance on how this disenfranchised group can vote going forward?
Well,
Because he kind of danced around the whole thing and kind of sneaked out without.
well, let me put it this way, Dan. Do you think anything that Justice Holmes told the people of Alabama would have allowed these black men to register to vote? Anything? Any suggestion? Any guides?
Short of federal intervention, probably not.
Yeah. Yes. I mean, that's the answer. Had he said, well, maybe you should do this, this, or this, but they weren't going to listen anyway. That's why I opened class with those two themes. So on the one hand, the court's basically leaving in place these discriminatory methods that disenfranchise blacks. On the other hand, the court didn't want to put a ruling out that would be ignored. On the other hand, by allowing the system to sustain, the court basically made it even harder, much later, to achieve any sort of equality. When people can't vote, the governments don't reflect them very well, right? Notice that Justice Harlan here jumped off board and he dissented. And he said the plaintiff is entitled to relief and he should be registered to vote. So these problems didn't seem to bother Justice Harlan that much in his brief dissenting opinion. Okay. Any questions on Giles? Yes, ma'am.
I'm just curious, it seems that the court would be interested in voting more so than education necessarily. So is it more so the time period that is the reason why they think their judgment wouldn't be upheld? Like that they wouldn't reinforce it the same way that schools would?
Well, let me ask you a question. What do you think would be easier for the court to supervise, elections or schools?
Elections happen on a one-day basis, so I would think that would be easier to supervise.
Yeah, that was my thinking also. It would probably be easier for the court to supervise elections held every year or two over schools, which are on a daily basis, right? So this is probably why Justice Harlan dissented, saying this is stupid. Just put the man in the voting rolls and let's see what happens, right? But it didn't happen.
So is it more the time period?
I don't think, I mean, between Giles, Cummings, and Berea College, the signal is pretty clear at that period. Any other questions on Giles? All right, in the back. Shelby, can you please tell me what happened in Berea College versus Kentucky?
Okay, so Berea College, they unlawfully had both black and white students together in the same institution. And there was an amendment that was passed that said that that was unlawful. So the issue was whether it conflicts with the federal constitution. And they go on to say that the statute was separable and that if they determined that it was unconstitutional to have the private and the corporation, both of them, to have black and white students taught together.
Okay. So Berea College is a Christian college in Kentucky. It was one of the first colleges in Kentucky to allow interracial education. At the time, most schools were segregated, but this school was founded on the principle that blacks and whites could study openly, equally. The state of Kentucky passed a law. And the purpose of the law was severalfold. It, of course, I shouldn't say of course, but as was the case back then, it was designed to segregate segregate public schools, okay? It would segregate public schools. Public schools are funded by tax dollars, and the government had the prerogative to decide how its schools will be run. But it went beyond that. It didn't just segregate public schools. It sought to segregate private schools. And it did this in 3 ways. First, it would fine any private school that allows the teaching of blacks and whites together. And, you know, was it $1,000 a day? I mean, we're talking about a lot of money, right? This is a lot of money back then and would be enough to put a school out of business. But it didn't just fine the school, it also fined the teacher. The teacher herself or himself would have to pay a fee. And oh, by the way, it didn't just fine the school and the teacher, it also fined the student. The student would have to pay a penalty or a tax if you're John Roberts, right? Everyone would have to pay money. It was actually as a tax on not going to an integrated school. That's all it was. Too early. Okay. So the government had this law, and they prosecuted Berea College, and they fined them. Okay. Now, we've discussed on several occasions that, private businesses are not bound by the 14th Amendment. So the 14th Amendment doesn't matter here. But historically, private businesses could do as they wish. And if a private business wishes to open its doors to blacks and whites, they could. This statute prohibited that. So, Michelle, how does the majority opinion explain this, right? How does the majority opinion say that these private schools are allowed to be regulated in this manner, where they can be criminalized for opening the doors to blacks and whites together? Ah. Exactly right. So all colleges are corporations, right? What the court says here, and this is a very flimsy argument, but the court says here is that corporations can exist only based on whatever the state lets them have, right? Corporations can only do what the state lets them have. So for example, if I want to go start teaching a school, right, and I petition the state of Texas for a corporation, they give me the corporation under certain conditions. I have to do this, I have to do this, I have to make these reportings, whatever. What the court says here is that the state has an absolute right to put limitations on how a corporation exercises its power. Therefore, it's not necessary to decide whether the statute is constitutional, because all we're looking at here is the corporation. Okay? Everyone get the majority opinion. It's very flimsy, but that's the reasoning. Again, you see the court latching onto this almost, facetious argument about why schools can be segregated to avoid the difficult questions that are raised by Justice Harlan's dissent. So everyone get the majority opinion of this corporation business. Cindy, what does Justice Harlan then say in his dissent? Is Justice Harlan, Cindy, convinced that this is all about corporate law, that this entire law is just a way of the state regulating corporate charters? No, I have to answer my question. Does Harlan think that this law was enacted as a way for the states to regulate corporations and their charters? Sorry? Why was this law enacted according to Justice Harlan? No. Why did Kentucky enact this law according to Justice Harlan? What was their motivation? Yes. Yes. Look at the name of the act. The act is called an Act to Prohibit White and Colored Persons from Attending the Same School. That was the name of the act, right? This law was designed to segregate private schools. This entire, pardon my French, BS about corporate charters is insane. Harlan said this was not the reason why this law was enacted. It applies not just to the schools, but to the teachers and even the students, right? Teachers are not corporations. Students are not corporations. They are punishing private conduct, right? That even if a teacher in her even if just say a person in the neighborhood held classes in her garden on weekends, no corporation or anything else, and there was a black student sitting next to a white student, she could then be arrested under this law. She's not a corporation. She's just, teaching people about the Bible on Sunday, whatever it is, in her garden. She's now subject to this law. So Harlan says that this entire case is insane, right? This is not what this law was designed to do. He says it's inconceivable that the legislature thought this was about regulating corporations. The manifest purpose was to prevent association of white and colored persons. Okay. But, Natalie, does Harlan come out and say that this law violates the Equal Protection Clause of the 14th Amendment? Does he say that? He does not say that. Why do you think he doesn't come out and say this violates the 14th Amendment? Why does Harlan not come out and say that this violates the 14th Amendment, Equal Protection Clause? What have we learned from the other cases today so far about the 14th Amendment? Try it, Whitney?
Yeah, he was saying that if they were gonna say that, prohibiting the two black and white students in the same school, it was essentially like opening the door to allow jurisdictions to say that blacks and whites couldn't close in church.
Oh, well, ooh, I thought you were going to be at the last second. You took a detour. You were really close. I thought you had it. Let me ask this question again. Why doesn't Harlan come out and just say this violates the 14th Amendment's Equal Protection Clause? You had it. But why does he go to this liberty route? Why doesn't he go to the equal protection route? You're answering my next question. Why doesn't he make the 14th Amendment equal protection argument? Anyone else?
Plessy,
Plessy. What about Plessy?
if he went straight on and typed Plessy, he would lose.
Well, he's in dissent anyway, right?
I mean, like,
Yeah, but you're right. He dissented in Plessy, right? If he comes out and says that the segregation of schools is unconstitutional, he'd be opening the door to Plessy. And if the dissent starts saying stuff about Plessy, that may push the majority opinion to say stuff about Plessy that's good. And it's almost like a game of, hot potato, keep away, right? They were trying to keep away Plessy, hot potato Plessy. We don't want to talk about it. We don't want to acknowledge, like Voldemort, right? We don't even want to acknowledge it. Pretend it doesn't exist. We'll get to it eventually, part 7, right? That was effectively the goal. And now, Whitney, your other answer was correct. So instead of going after the 14th Amendment, what approach does Harlan use to say that this is unconstitutional? You already said it.
He was just saying that if they segregate them in schools, then they'll end up segregating them everywhere.
Such as, you said it before. You said it before correctly.
Voluntary, like worship.
Church is religion. So we haven't discussed the First Amendment much yet, but at the time, the First Amendment, which begins, Congress shall make no law abridging the freedom of speech, blah, 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 only applied to the federal government. It had not yet been extended or incorporated to the states. So what Harlan's effectively arguing is that the liberty interest of the 14th Amendment, what's called substantive due process, we'll discuss this later, substantive due process, there's actually a substantive right to teach and learn. Right? There's a right to teach and learn, particularly in religious instructions. Harlan was a Sunday school teacher. He loved teaching about the Bible. So he knew this well. He's saying that, look, I can't rule the 14th Amendment, equal protection, but also you have a liberty interest. You have a liberty interest in education. We'll do a case later called Pierce v. Society of Sisters. in Meyer v. Nebraska. In Myers v. Nebraska, the state of Nebraska tried to ban teaching of German. Why? There was a lot of anti-German animosity during World War I. In a Pierce v. Society of Sisters, the state of Oregon tried to shut down all Catholic schools. Why? There was a lot of anti-Catholic bigotry. And the court said you have a right to the school of your choice, right? So this idea of a liberty interest was an alternate way of getting there. That this is void, and we should not be allowing this to happen. But again, the majority opinion ducked the 14th Amendment, hot potato, and they said nothing about the constitutionality of the program and put forward this ridiculous reasoning about corporate charters. Okay. Questions on Giles, Berea College, Cumming? Oh, sorry, I didn't see you. He ignored the 14th Amendment's Equal Protection Clause. Other questions on Berea? And Berea College is actually still in effect. I think it's not quite a vocational school, but close to it. And it's actually a very important institution to giving people careers. Very, very good school. Yes, ma'am.
There are a lot of different sections in that statute, and the first one was the one that talks about like segregation. So, in the majority, were they talking about all of the sections, or just?
They were only talking about the section involving the corporation, because the only defendant was a corporation, right? The only defendant was a corporation. He was the only person charged.
So what happens with the other sections?
Well,
They didn't talk about it.
they didn't talk about it. Now, had the state of Kentucky charged not only the corporation, but also a teacher, then they would have had to talk about it as well. But a teacher was not charged under this law. Questions on Berea? Yeah.
I had a question that notes we were talking about. I don't remember what the which case owes the Bob Jones University and removing the federal funding. To me, I don't really see like how are those the same. It's one thing to say you can't make a law criminalizing a completely private corporation doing something versus okay, if you can discriminate if you want, you just don't give federal money to do it. To me, those are two. How do those two coincide?
So the Bob Jones case involved Bob Jones University, which was a Christian college in South Carolina. And until the 1980s, or I think the 70s even, the schools did not allow interracial dating on campus. It was a segregated admission policy, and they basically did not allow any interracial dating. The IRS threatened to take away their tax-exempt status, and the school raised various claims under the First Amendment, free association, and freedom of religion. And the court upheld the decision to rescind their tax-exempt status unless they came into compliance. Now, I'll update that. So during the oral arguments in Obergefell v. Hodges, a same-sex marriage case, oh God, it was about a year ago now. It was a year ago this week. I think it was Justice Alito asked the Solicitor General, what happens if you have a private religious college that refuses to give same-sex couples married dormitories? Could that school then lose their federal funding? And the Solicitor General answered something very interesting. He said, that's going to be an issue. That's going to be an issue. That's what he said. So to the point about Bob Jones, the question becomes whether would then removing sorts of federal funding or tax-exempt status impose a substantial burden on the college's religious exercise, which is indeed the question in the Little Sisters case, which I will be going to in about 40 minutes. So it's a live issue, Samuel. I mean, it's a live issue. These issues are still working through, and whether various protections for religious liberty can be used for various religious colleges that do not wish to comply. I'll give you another example. Some states have passed laws saying that adoption agencies cannot discriminate against whom children go to. So say if a Catholic adoption agency will not place a child with a gay couple, states have passed laws saying you can't provide adoptions in our state. And the Catholic charities have said, okay, we won't. And they've given up on helping adoptions. Certain segments exit. That is, various religious groups simply exit from various spheres of social services. We see a couple Christian colleges tell its students we would no longer accept federal financial aid. So I think you'll start seeing this more and more and more. That was a very roundabout way of answering your question. Not at all.
Another thing, and this is more theoretical, say the whole, well, you can tell a state can tell a corporation what to do, they can't tell an individual what to do with regards to that. In Harlan's dissent. If that had carried the day, and then when you got to Citizens United, where corporations are people, would that have thrown that case into question?
Well, the doctrine that corporations are people came long before Citizens United. The case I mentioned a moment ago, Pierce v. Society of Sisters, was a religious school that asserted the right to teach. A corporation asserted the right to have constitutional rights. This is a doctrine that long predates 2010. So Citizens United doesn't really have much to say.
I just mean that as a concept in general with regards to
there's nothing particularly unique in the law about corporations having rights. Corporations are merely made up of their shareholders, and they speak through their conduits. So to the extent that a constitutional right is being violated, a corporation can assert itself on its behalf. Go think of any case called ACLU versus someone, or NAACP versus someone, or New York Times versus Sullivan. There are lots of cases with corporations as the parties. It's not a particularly controversial thing, although people make a big deal about it. All right, other cases on Giles or Berea or Cumming? All right, let's move on to Brown. I think I always mentioned, going into law school, there's probably like 2 or 3 cases that every law student knows. You know, they know Roe v. Wade, they know Marbury versus Madison, and they know Brown versus Board of Education. And the facts of Brown are known to everyone. You have segregated schools. Everyone knows about the segregated schools. Everyone knows about Plessy versus Ferguson. But very few people actually know what Brown said. How many of you, when you read it, were somewhat surprised / underwhelmed? Yeah. Every year I read it, I'm thinking, okay, this is like this big magisterial case we're supposed to read about, and it's a couple pages long, and doesn't really do what I thought it would do. Right? I always thought when I got to law school that Brown would overturn Plessy and have this beautiful statement about a colorblind constitution. And it doesn't do that. So let's talk about the background. So after the initial failings of Cummings, Giles, and Berea College, the NAACP, the National Association of Colored People, so their legal defense fund, which was led by a guy named Thurgood Marshall, who became a justice, hatched a strategy. And they realized that it was impossible in one day to overturn Plessy. They realized it was impossible to overturn Plessy. So what they set out to do was, in a series of cases, chip away at the doctrine. The ultimate end goal was to end segregation in public schools, right? That was the end goal. But they started elsewhere. So actually, one of the first places they started, figuratively, is a place with married to lawyers, which is law schools. So everyone knows we have several law schools in Houston. We have U of H, we have South Texas, and we have Texas Southern, which is now named the Thurgood Marshall Law School. Does anyone know why Thurgood Marshall Law School exists in Houston? You know the reason why? I had a student transfer from here last year. Yeah,
Stab at it.
go for it.
Is it because U of H in South Texas limited black students?
No, in fact, that's wrong. U of H, South Texas did. I don't know about U of H, but South Texas did. Yeah. So at the time, UT of Austin was segregated. UT Austin was segregated. And UT refused to admit black students. So what did Texas do? Well, under Plessy, separate but equal. They said, okay, we'll make a different law school. We'll call it Texas Southern Law School in Houston. And if you're black, you can go there for college. Right? That way black kids can get law school. TSU is just as good as UT. Okay. So I'm not trying to be mean to either school, but that probably is not true today. It wasn't true 50 years ago. But that was the argument. So the case of Sweat against Painter went to the Supreme Court. And the Supreme Court held that no. These law schools are not equal. You need to admit law students who are black to UT Austin if they get in. So that desegregated the University of Texas at Austin. It was actually another case involving schools in Oklahoma where they basically made a secondary school that wasn't as good. Okay. But that brings us then to Brown, right? They had gotten to the point where for specialized college education, the court was willing to hold that separate, you had to have equal admission, right? These different law schools were not the same thing. But what about for primary school? So I have some pictures to show you. I love pictures. This is Linda Brown. She was the lead plaintiff. And if you think the name Brown is a memorable name, that was deliberate, right? The people designing these cases were very smart. This is Brown's family. Let me show you this picture. These were the different plaintiffs in the case. There's I have it. This is Vicki Henderson, Donald Henderson, Linda Brown, James Emanuel, Nancy Todd, and Catherine Carper. I love this picture, right? So look at these kids. They're adorable, right? These kids were picked very deliberately because they're cute and they're sweet. And how can you say no to these cute little kids? Like these kids, they're cute with a little button, the little uniforms, their shoes and everything, right? The people putting these lawsuits together were very smart civil rights lawyers. And they know that if you bring cute kids to a hearing, that gives you that much extra help with the judge, right? Let's see this picture. Okay. A picture of them somewhere. Yeah, these were actually some of the lawyers. This is Thurgood Marshall when the lawyers argued the case. They recognized that the time was right by the 1950s to actually bring a full challenge to Plessy versus Ferguson. They realized that now is a time that we may actually be able to get a victory at the Supreme Court. So they picked Brown, Linda Brown. Here's some pictures of her high school. This is Monroe Elementary School in Topeka, Kansas. It was about 21 blocks. I'm sorry. The white school a few blocks away from where she lived. The black school was about 21 blocks where she lived. So it was a pretty far way to go to the segregated school. If you actually go there today, it's a museum. And they've restored it to how it looked at the time. And you can actually see, white and colored signs separating them. It's actually a national museum. And here are some of the pictures from inside the classroom in the school I found. Okay, so what else we got? Okay. This was the all-white school nearby that was much closer to where she lived. And basically, Brown filed suit saying, I want to go to the school close to my house, not this segregated school across town. So the actual history of the case, I'll get to the case in a minute, it's interesting. The case was argued the first time under the leadership of Chief Justice Fred Vinson. Vinson was a Truman appointee. And after the initial vote, the vote was divided. It wasn't unanimous. There were enough votes to invalidate the segregated schools, but there was a strong sense that they wanted this vote to be unanimous, that the court should speak with one voice. So the court then had something crazy happen. Chief Justice Vinson died of a heart attack very suddenly. And President Eisenhower made a recess appointment of Earl Warren, who was the governor of California, to the Supreme Court. And Earl Warren came in and said, you know what, let's re-argue the case. Earl Warren was a politician, among anything else. And his mission was to cobble together a 9-0 majority opinion, unanimous. And he was able to do that. So one of the reasons why the Brown decision is so unsatisfying and so short and so, bland is because Chief Justice Warren had to use language that would appeal to every single member of the court. That's why the opinion reads the way it does. And then ultimately he was able to get a unanimous decision. So this is actually a letter from Justice Frankfurter to Justice Warren. And it said, "Dear Chief, this is a day that will live in glory. It is also a great day in the history of the court." Okay? "And not in the least for the course of deliberations which brought about the results. I congratulate you." So there was a huge celebration at the court afterwards. I'll get to the opinion in a minute, but like the story is more interesting. It is. And here's actually Marshall and a couple of his colleagues celebrating the courthouse steps after the case was decided. These were all the lawyers in the NAACP Legal Defense Fund. And this is a photograph which, looks spontaneous, but I'm sure it was staged many times, right? It's Linda Brown with her mom sitting on the steps of the courthouse with a newspaper, and it says, "High Court bans segregation in public schools." You can imagine the little girl sitting there, reading this newspaper. It's pretty powerful image, but very well staged photo op. And here's the actual newspaper. It says, "Segregation in public schools ended by court. Ruled unconstitutional by Supreme Court. Date to end practice not set." That's an important sentence, right? Oh, and by the way, here's Spotswood Bolling. He was a plaintiff in the other case, Bolling v. Sharpe. He was from the District of Columbia. So let's actually talk about the case now. I'll leave this picture. This picture works. Yes, you're up, sir. I don't need to ask you where the facts of the case. How does the court go about finding that the segregation of the public schools is unconstitutional? The original what? Yeah. Okay, stop there. So very good. The first part of the court's opinion is they try to look at what's often called originalism. The idea that we should understand how they were originally understood at the time of their framing, or perhaps how the framers intended it. And the court finds that originalism is not particularly helpful. For one, there wasn't really public schools back to the time of the 14th Amendment, right? And to the extent that they were, only rich people went to them. Furthermore, the court notes that at the time of the 14th Amendment's ratification, the public schools in the District of Columbia, which were under federal control by Congress, were segregated. So they basically say, well, this history is not very helpful. Now, there's a vigorous debate on this issue, and a professor, Michael McConnell, who an article mentioned in your notes, is also one of the editors of your book, which is not a surprise. Michael McConnell argues that indeed, if you look at the history of the 14th Amendment and the years thereafter, there was very strong support to integrate schools. But one of the key challenges of originalism as a theory is how to explain segregation in schools. And Justice Scalia was recently asked, as I suppose time will elapse, Justice Scalia was recently asked about Brown and originalism, and his answer was, no theory is perfect. So I'll give you that. So the court moves past any sort of originalism to looking at the history of the 14th Amendment. So then, Sean, what then does the court rely its decision on?
It goes on to note basically the futility of the education system, how the federal and state governments are control of that, because they are, that's like the main factors of the and that's the deciding factor that the segregation is inherently discriminatory.
Why, let me ask a question like this. Why is segregation education so bad, does the court say? What about segregation education is so bad?
It says that there's a sense of individuality.
Good.
And so the students in the heart and the mind, they feel it just by the segregation between schools, and that even if all the tangible aspects of the schools are equal,
Good. Okay, this is what I want you to remember, right? Brown does not come out and say Plessy is overruled. It does not do that. Brown does not say that separate is not equal. They make a very narrow, very precise argument. They say that with respect to education, separate schools is not equal. If students are segregated, the court says, they're not getting an equal education. Therefore, separate cannot be equal. Everyone said it's limited to the idea of education. That if students are in different schools, they'll feel inferior, and even if the accommodations are equal, they will not get an equal education. Therefore, separate is not equal for education. And in the famous footnote 11, you circle footnote 11 in your reading, the court cites all these social science articles, right? Anyone ever hear of that marshmallow test or any of the Barbie doll test, any of these other tests? So kids are often given these various tests to try and figure out, mental whatever. And one test is a child is given a black doll and a white doll, right? And they don't know about these? And they say, which one do you pick? And when you have these sorts of segregated schools, even the black kids start reaching for the white doll. And these are some of the studies that are footnote to suggest that allowing these segregated schools to continue breeds this sort of inferiority, the second-class sense among people. And you can't possibly have a good education with this regime in place. Okay? So that's it, right? It seems underwhelming, but that's basically holding it Brown. Because segregated schools cannot give an equal education, they're unconstitutional. Any question? I mean, I'm not exaggerating. That's basically the holding Brown. Everyone get that much. That's not the fun part. The fun part is what comes next. Okay? At the very end of the opinion, we get to the, okay, now what? Right? What do we do? The court schedules the case for re-argument. Says, okay, we've just laid down this principle that separate education is not constitutional. What are we going to do now? So they re-argue the case a year later, right? And that brings us to Brown number 2. And in Brown number 2, they say, okay, we had this first case, Brown 1. We said that the schools can't be segregated. Now we have Brown 2. What the court does in Brown 2 is they say these are local problems. And in order to address these local problems, the lower courts are required to maintain supervision over the school boards. The lower courts are required to maintain supervision. So think about that. In Giles and Cummings, the court said, look, courts can't supervise elections. They can't supervise voting regimes, right? They can't supervise school boards. In Brown, the court did exactly what they said they could not do 50 years earlier. Everyone understand that. In Brown 2, the court said we will now supervise through the lower courts, local school boards. And this is what gave rise to Cooper v. Aaron, the Arkansas, the Little Rock 9 case, right? The reason why the Little Rock 9 case happened is that there was Brown, a judge in Arkansas said, okay, Central High School, you guys have to desegregate now. And the governor said no. And the Supreme Court said, no, you got to desegregate now. And the governor said no. And that's when Eisenhower sent in the federal troops. This is what happened before. Brown 2 said we are giving these lower courts the power to supervise over integration, and because the governor basically ignored them. So this entire Brown 2 strategy, right, said you guys have to desegregate with, quote, all deliberate speed. If I notice that word, all deliberate speed. The southern states said, yeah, right, make me. And then the federal troops made them. But this is why the Brown 2 strategy was risky. By basically putting federal courts and federal judges to supervise the integration of schools, the courts are putting entire governments under federal control. People saw this as a reintroduction of Reconstruction, right? That these federal, officers are now monitoring how they administer their government. It was really a remarkable order, and it was only by the fates of time that it actually worked out. Even today, in the year 2016, there are still school districts that are under supervision by federal judges. And by the way, these judges have lived and died. They keep substituting from one judge to the next to the next. But there are some judges who still supervise these cases. And let me tell you, some of these judges had bodyguards for years. Some of these judges got very threatening phone calls to their homes. They got packages on their doorsteps, right? These judges were in very risky situations. You even had a lot of visiting judges from up north come down just to do these hearings and get the hell out of town as quickly as they can. This was not a laughing matter.
Where are some of these cases where they're still supervised?
I know there's one in Jacksonville, Florida, that I'm aware of. I don't know others, but I definitely know Jacksonville because I know the judge who's on it. Yeah.
So like they go through all of this like turbulence, like in like supervising like local school boards, right? And so, I mean, we still don't have an answer even after Brown why people still like, because when I asked you earlier what kept the court system, what kept the other branches from cooperating, you told me, do you think these people would have really, do you think the public opinion and that sort of the general attitude towards integration would have like allowed, for like successful intervention? Seems like successful intervention didn't really happen. The court just finally decided. What happened before this, right?
So Mirza, what is this picture on the board? Field. What does this thing look like? You don't know what this looks like? No? It's a diving board. So this is a case of Palmer v. Thompson. At one point, this was a pool in Jackson, Mississippi. A federal court ordered that the city integrate the public pool. Mirza, what did the city do instead of integrating the public pool? They filled it with concrete. Right, a little cement pond, to use Beverly Hillbillies, right? What actually integrated schools, what integrated the workplace, was not the courts. It was Congress. The Civil Rights Act of 1964 and various other federal laws put the force of the federal government behind integration. While in this building you have a very court-centric view of the world, don't fool yourselves for a minute that Brown did very little to desegregate schools. We can cheer these orders all day long, right? But it was actually Congress and the president taking discrete actions. That's what did it. There's a reason why 40 years after Brown, people are still ignoring those courts.
You said it was the lower courts were supervising the federal code.
Yes, sir. And I showed you these pictures before, but basically, this was in 1963. 9 years after Brown, okay? We're talking about a decade, right? 9 years after Brown, you still had federal troops walking kids into school. The opinion did very little, strikingly little. So don't fool yourselves for a minute. Brown was a great moral victory for the court, but it had very little immediate impact. I mean, 9 years after Brown, you still have this. Did you know that in Virginia, school districts, rather than integrate, shut down? Cities just start handing out vouchers to go to a private school. Entire school districts shut down rather than integrate.
So earlier you said that the courts didn't want to make decisions that would be ignored. This is an example.
Isn't it?
Exactly that.
Well, Earl Warren, the Chief Justice, decided that that's what they wanted to do. I mean, you saw throughout the South billboards that said impeach Earl Warren. You can Google these pictures. And 9 years later, had President Eisenhower not sent the federal troops, right? What would have happened? I'm sorry. This is 1957, the Little Rock Nine. 1963 was George Wallace, so I got my years wrong. But yeah, 5 years later, if Eisenhower hadn't sent the troops, then whatever.
So do you think the lack of respect or maybe the ignorance of the general population that we spoke about before class about how most people you ask when you know a Supreme Court justice, do you think that adds to the people ignoring decisions like this? These
decisions became very well known. The so-called Warren Court became a very known quantity in American history because they issued a series of rulings that radically altered how governments work. It's often viewed as a liberal heyday of the court, that they had things like Miranda and all these other decisions, but there were certain structural decisions that changed the way governments function, and these were very visible to people, particularly in the American South. Garcia? Yep.
So basically, from what I got from it is that part of it was they were saying that things didn't show that education is a fundamental right. It was making me think of the case we just talked about education. I mean, it's almost a national law thing. And they said that it didn't violate protection.
Can you ask me about this when we do substantive due process in a couple weeks? The short answer is that fundamental right has a very strong weight, but we'll come back to it in a few weeks. So everyone get the idea of Brown, right? The decision by itself didn't do that much. It was a slow, gradual accretion, year after year after year, until finally, states started to fall into line, but it took a while. Years and years and years passed. It was not overnight. Okay, I want to draw your attention briefly to the case of Bolling against Sharpe. Okay, Bolling v. Sharpe was a segregation case brought from the District of Columbia. The District of Columbia is bound by the Fifth Amendment, not by the 14th Amendment. Okay, so here's the dilemma. The 14th Amendment has an equal protection clause. The Fifth Amendment does not. The 14th Amendment says states cannot deny anyone the equal protection of the laws. The Fifth Amendment does not. So what provision of the Constitution prevents the federal government from discriminating? Well, the court, in one of the most decisions of all time, they said, well, we will treat the due process clause of the Fifth Amendment as expressing an equal protection principle. That even though the Fifth Amendment does not impose any equal protection guarantee on the federal government, we will treat it as if it did. This is what's called reverse incorporation. That an amendment enacted in 1868 can go back in time and modify the Fifth Amendment enacted in 1791. This is the, what are we going to do? We have to do something about DC. Let's just make something up. I don't mean to be too glib, but this is almost like, the evidence is they almost forgot about this case. That the text of the Constitution mattered so little for this. Some of them almost forgot that the 14th Amendment didn't control the DC public schools. So they had to go back and make up this holding. Okay? And they said, practically speaking, it makes sense. Why? Well, how could it be that the states can't have segregated schools, but Congress could? Okay. Any questions on Bolling against Sharpe? Yeah.
So is that argument used in Heller?
Well, the Second Amendment applies to DC because it was incorporated by the 14th. We'll do the incorporation doctrine later. I'm sorry, I said this is where I'm sick. The Second Amendment applies directly to the District of Columbia. You don't need anything else.
What is the 14th?
What does the 14th Amendment say?
Does it say?
No state. The Fifth Amendment and the Second Amendment apply directly to the federal government. The 14th applies directly to the states. The Fifth Amendment does not apply to the states.
But there's still a lot of disagreement about whether the Second Amendment really does apply to DC.
Not really. Well, I mean, there's no question the Second Amendment applies to DC. The question is, what does the Second Amendment mean? There was a question whether the Second Amendment is incorporated to the other states, but there was not much of a question whether it applies to DC. Okay. Questions? Yeah. Which case? The reason why is because DC is a federal territory. The 14th Amendment does not apply to it. So they needed to go to the Fifth Amendment to make something that makes sense. So the Fifth Amendment says, I have it up here, no person should be deprived of life, liberty, or property without due process of law. And they're basically arguing that one of the liberty interests protected by this is the right not to be discriminated against. That is, a liberty interest to be free of discrimination. But that sounds an awful lot like equal protection. They're basically dragging the equal protection clause into the liberty provision of the Fifth Amendment. It's gobbledygook. It's not real law, but they had to do this part of the ruling. Okay. Questions? All right. All right, we'll end here. Thank you very much. I'll see you all on the flip side.